so we may not be coming in very often. Okay? So over to you, Saila and Arvind.
Sayantan, would you like to do your housekeeping first?
Can you all see my screen?
Yes, yeah.
Yes, it's visible.
Okay, I will just start slideshow. Okay, welcome everybody to week 4. Today we'll cover the preamble and the basic structure doctrine, which we'll get to know shortly. These are things we're familiar with, but it's always nice to reiterate. Keep a video on if possible. Pause the speakers anytime and ask questions, put it in the chat. If you're not speaking, please put yourselves on mute so others can hear properly. Feel free to take bio breaks or stretch breaks, and we'll hope to have some discussions today. But otherwise, we can again meet on a weekend or some other time to discuss what this sort of session evoked in us. Today's session is, just ignore from secular onwards. But today we'll basically be covering all the aspects of the preamble, and then Arvind will be taking us through the basic structure doctrine with special reference to the Keshan and the Bharti case. So with that, yeah, over to you.
Yeah. Thanks, Sayantan. Yeah. I think the rest of the session today is going to focus on this one page, which is the preamble to the Indian Constitution. The reason why we felt that this entire session should be devoted to this, because this is in essence the Constitution of India. Now I know generally the word preamble, no, Sayantan, just don't change until I tell you, because actually I may not even move on to the other slides. I would like to stay on this slide for some time. So the preamble, most of you have, I mean, you all know the English dictionary meaning of preamble, isn't it? It is either a preface or an introduction to any book, anything. So that is generally how we understand the preamble. One interesting fact about the preamble to the Indian Constitution is that in fact it was written after the entire draft constitution was ready. So it was written right at the end. So in a way, this preamble is a summary of the entire constitution, and it captures the most essential features of the constitution. And I think the constitution makers wrapped it up in one page, the entire lengthy constitution. And I think it could not have been expressed in a much better way. So let us see whether it's really reflecting the entire constitution. I think on the first day, Arvind had mentioned that actually the constitution is just a footnote to the preamble. So actually it is in a way now let us see what the constitution has to say. Now, what do we mean by we, the people of India? So there's the word we, the people of India, simple as it may seem, has been also a subject matter of discussion. Now, who are these people of India? Is it the people of India who lived at the time of the Constituent Assembly, which means like most of them are dead? So does it mean that the language of the Constitution, we, the people of India, is no longer relevant? Does it mean that none of us can actually identify with the term we, the people of India? But then when we understand the Constitution, not as some document which was framed long ago by some set of people and who are no longer now with us, if we see the Constitution as a living document, which is what the Supreme Court has said, that it is a living document, and the interpretation of the Constitution changes with time, changing with the current situation. So when we look at it as a living document, then the term we, the people of India, means every person living in India. And it is a continuous process. It is applicable to generation of generation. And each one of us can identify ourselves as being part of this we, the people of India. Now, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic. I think in the recent past, there has been a lot of discussion about this socialist and secular being an addition brought in by Mrs. Gandhi during the emergency, and hence there was a challenge which has now finally been settled and they have repelled the challenge. But I think there has always been a parallel discussion among people saying that it is really not relevant whether this, even without the word socialist, secular in the text of the constitution, the meaning behind, the essence, the principles of socialism and secularism are embedded in every part of the constitution, including the preamble. So let us see how it is embedded as we go on. So what does a sovereign nation mean? So we are no longer under the control or under the rule of a foreign entity. And we are sovereign in the sense, like today we make our own laws, we govern ourselves, we have our parliament, and we have our assemblies where we make laws for ourselves. Now, where is this? Yes, this is external sovereignty and internal sovereignty, which is what, can we go back to the earlier slide, Saintan? Because I would like people to look at the constitution as a whole. Now, because I think all of us should just get this page should be imprinted in all our memories, I think. It's a very, very important document. So when we are looking at socialist, secular, just go down. Socialist is, can any of you identify if, even if that term socialist was not there where it is located today, can we still read socialism into this document? Anybody? Can anybody take a try?
Yes, it's justice, economic and social. Economic justice is socialist.
Yes. So when we are talking of justice, social, economic, and political, what else but socialist is it? Then socialism. So even without that term, we don't even need to travel as far as the directive principles of state policy to say that, you know, socialism is embedded in the constitution. Even within the preamble, without the word socialist, if you just move down, just as somebody has pointed out, justice, social, economic, and political. So what is social and economic justice except socialism? Now the next word is secular. Then again, there's been a lot of hue and cry about how secularism is something which was brought in. It was not there in the original constitution. So implying indirectly that it was never, our country was never meant to be secular. Now just go to the next line. Do you find the secularism in the preamble itself? Again, anybody? Just stay with the first slide, Saintan. Stay with the first slide.
The liberty of thought, expression, belief, faith, and worship.
Exactly. So when we are talking of liberty of thought, expression, belief, faith, and worship. So there it is, secularism staring at us. So now we don't need to travel beyond the preamble to tell us that we were anyway, the constitution makers anyway envisaged the country to be socialist and secular. And so today's entire WhatsApp campaigning that socialism and secularism is something which is alien to India and it was never part of the original constitution and it was only introduced during the emergency time. The fact that the subsequent elected parliament did not choose to repeal this, though they repealed many parts of the amendments which were brought in during the emergency. I mean, people would like to ignore all that. So even without going into the politics of that time, what I would like to impress upon all of you is that even without the word socialist, secular in the preamble, even if it were taken away, the essence, the meaning of socialist and secular is very much part of the preamble itself. So that's one thing which I would like to point out to each one of you. And then democratic republic. Again, democratic. If you're looking at the word democracy, we all know that we are actually, I mean, we are a universal adult franchise. We have elected governments. So as opposed to democratic republic, as opposed to a monarchy or a authoritarian regime or a dictatorship, a democratic republic. Now going back to the first thing when I said that the rest of the constitution is really a footnote to the preamble. Now, if we go back to each parts of the constitution, which we pointed out in the very first session, explaining part 1, part 2, part 3, part 4, part 5, etc. The larger part of the subsequent sections, apart from part 3 and part 4, you would find the rest of it is actually expanding on, giving us a mechanism for enforcing this democratic republic. Now, when you say that we are declaring ourselves to be democratic, now how do we enforce this democracy? Now, how do we structure this democracy? When we say we are a republic, we are not a monarchy, we are not a dictatorship, then how do we create mechanisms to ensure that these goals are achieved? That's what the rest of the constitution is all about, where we have the union list, the state list, the entire how central government, how is it to be constituted, the state governments, assemblies, how are they to function, the emergency of the financial powers, all that is nothing but giving us a mechanism to achieve the goals of the preamble. So in that way, yes, it is a footnote. The rest of the constitution is a footnote to the preamble. Now, justice, social, economic, and political. Liberty of thought, expression, belief, faith, and worship, equality of status and opportunity. So justice, liberty, and equality. For the history students, you would note that this was the cry of the French Revolution. So justice, liberty, and equality. So we have actually learned from the histories of the world, and we have tried to incorporate the learnings that we have seen. That was the time of the Second World War, Nazi Germany, what could happen if these kind of rights were not expressly expressed, and we have incorporated all that right in the preamble. And now, how do we ensure that this justice, liberty, and equality is actually achieved? That's what part 3 is all about. So part 3 and part 4 is all about ensuring these 3 principles of justice, liberty, and equality. And the next word is fraternity. Fraternity, assuring the dignity of the individual and the unity and integrity of the nation. Yes, fraternity is also very much a part of part 3 and part 4. And we will need to also highlight Article 17, which abolishes untouchability, because I think untouchability is the worst form of robbing the dignity of an individual, and there can never ever be fraternity in this country unless we all address casteism in our country. And hence, the founding persons of the Constitution felt it fit that we should bring in fraternity, assuring the dignity of the individual and the unity and the integrity of the nation. And I think on the last occasion, just to kind of remind you of the earlier discussions, I think Arvind had pointed out when we were, how if you look at it, the way it has been very interestingly ordered. Fraternity can, only if there is fraternity, the dignity of the individual can be assured. And only if those two are achieved, can the unity and integrity of the nation be maintained. So I think this was very nicely pointed out by Arvind in the earlier session. So I just thought the reason why I decided that we should stick on to this one screen before we move on to the other slides, it is only to see how the whole thing is so seamlessly capturing all the parts of the Constitution, which is which is Article 1, which tells you which is the territory of India. So solemnly resolved to constitute India. Now, what is India? What is India is there in part 1 of the Constitution, which is giving you the territory read with the schedules. Then sovereignty, socialist, secular, democratic republic is the rest of the chapters of the Constitution. And justice, liberty, equality, fraternity, you will find in part 3 and part 4. So in essence, this preamble is the entire Constitution in a capsule. So that is the reason why I thought we should stay with this page. Yes, now we can move on to the next slide, Santh. Sayantan, we can move on.
Yeah, I've moved on. Are you unable to see?
Sure.
We the people of
Thank you.
India?
Yeah.
Okay. Sorry, there's a lag
So
on mine.
now, yeah, so now we're just elaborating on what we have already discussed, just broken down the constitution into separate slides so that each aspect, each component of the preamble can stay with each one of us and, to drive home the point a little better. So we, the people of India, having solemnly resolved, and the people of India is seen here as a source of power. So it is not the Queen of England or the King of England who's giving us, the mandate, or it's not somebody sitting elsewhere who's telling us what to do and what we. And you must remember that the Constituent Assembly itself was actually under a law enacted by the British. So now when we have given ourselves a constitution, the source of power which is given to our parliamentarians is the people of India. So ultimately, the people are supreme, the people are sovereign. So it is that idea which I think the opening sentences of the preamble seeks to drive home. And that also places a larger responsibility on each one of us, that unless we as the people of India recognize that we are the source of power, and if our parliamentarians are enacting laws, the source, it is a power given by all of us. And it is not just the vote every 5 years. It is a continuing source of power. And so it is still within the people of India to actually change the course of this country and guide it towards the preamble of the Constitution. Then more than just a rhetoric.
Saila, if I can
Yes?
come in for a moment here.
Please.
Recently also this issue came, especially with this one nation, one election type of a thing, where the whole issue is who has sovereignty. Is it sovereignty rests with the parliament or is it with the constitution? And constitution, as Saila had said earlier, the power rests with the people of India. And the Supreme Court has recently also said, and earlier has also said, it's the sovereignty not with the rest with the parliament, because parliament is brute majority also, but it is with the people of India. And therefore we need to keep in mind that it is us, all of us who are listening to it, and the 1.4 billion people who are our co-citizens. It is us which gives the source of power to govern ourselves, which is why we need to keep fighting to keep this constitution alive and growing. Over to you, Saila.
Yeah, so the next sentence there, more than just a rhetoric, but a reminder that we are an independent republic who govern ourselves. So unless we are constantly telling ourselves that we need to engage with what is happening in the country, we need to keep engaged with all the issues. And if we want to bring, like Mahatma Gandhi said, be the change that you want to be. So the change has to start from us. And this is a reminder. That is why the preamble is so important. During the CAA, I think after a long time, I think maybe not for the first time, but in a long time after the independence, I think suddenly the whole nation woke up to the fact that the constitution and the rights that we all took for granted, are in danger of being totally eroded. That's when all of us woke up to the preamble suddenly. And we have had people across the nation reading the preamble. In fact, in the courts, lawyers got together in large numbers. We did it in the Madras High Court. We stood outside the High Court, and unfortunately, we were not given permission to read the Constitution inside the High Court. That's the irony. But we all assembled just outside the compound of the High Court, and we all collectively read out the preamble to the Indian Constitution. So somewhere, I think, and every word of when it was under threat, the fact that the values that we took for granted, suddenly we thought that they are just slipping away from us, and we are now going to see a India which is not what we thought we were. We just took the whole thing for granted. So at that time, I think all of us found strength in reading the preamble, and that is the real power of the preamble, which again is the people of India, which means all of us here today. Yeah, next. So again, we're just expanding on the word sovereign. So sovereignty is two types of sovereignty. One is external sovereignty, which is we are an independent state. not subject to any external power for anything. So we have the independent, we are an independent entity. We can engage with other states in a manner which we think fit, and evolve our own policies of interaction with other sovereign nations. So that's part of our external sovereignty. And the internal sovereignty, power to legitimately legislate on any subject within the country. The only source of limitation of the powers to legislate is as per the Constitution. So yes, as our democratic, our parliaments can legislate, bring about any kind of law, but what are the limits of this power is what we are going to see in the second half, which is the basic structure of the Constitution, which will be dealt with by Arvind later. But while yes, the Constitution, we are sovereign, internal sovereignty is there. There are also limits for this internal sovereignty in a manner in which it protects, in fact, the people and the basic values of the Constitution. Next. Socialist is a principle to eliminate inequality in income, status, and standards of life. We have just taken out extracts, that is the Nakara versus Union of India, which was a case dealing with pensions, where the Supreme Court had extensively dealt with the right to pension. In that context, they said that ultimately they rely, when in interpreting, see, the Constitution is very often used by courts to interpret provisions of law, to interpret the validity of enactments. Now, whether a particular enactment or a particular rule is furthering the constitutional goal as set out in the preamble, or is it taking away from it? That is a very good measure to check whether a particular enactment is constitutionally valid or not. So in Nakara case, they rely on the socialists, the word socialism in the preamble, and they say that this principle is to eliminate inequality in income, status, and standards of life. So, as I had already explained, while this was added in the Constitution by the 42nd Amendment of 1976, so mark the year 1976 because ironically it was during the emergency, and its principles are already stated in the Directive Principles of State Policy. And as I already pointed out, it's not just the Directive Principles of State Policy. The preamble itself has actually, encapsulated the essence of socialism. Next. Secular. Again, once again added to the preamble by the 42nd Constitutional Amendment. However, the principles of secularism are reflected from the beginning in the preamble fundamental rights and the right to equality, 1516, no discrimination on grounds of religion, etc., and the right to freedom of religion. 25 to 28, it not only just protects freedom of religion, in a way ours is the only constitution which also gives us the right to protect our own culture. So this is what else but secularism. So this is again, I think each one of us needs to understand that when we are talking about a particular word or a particular term, it is not necessary that we just turn to one particular provision of the Constitution. Sometimes many provisions read together, many provisions operating in different spheres, a cluster of provisions could all put together convey a particular principle of law. And the word secularism, in fact, runs through the entire Constitution, as pointed out. Next, Sayantan. Constitution prohibits establishment of a theocratic state. Now, there is no, when we have worded it that way, it doesn't mean to say that there is something in the Constitution which says a theocratic state is hereby prohibited. The very fact that we have declared ourselves to be a democratic republic, inbuilt into that is this, that we are not permitted to declare to have a theocratic state, or the Constitution does not permit establishment of a theocratic state. State is prohibited from establishing any religion of its own. State, if prohibited, is prohibited from identifying with or in favor of any religion. Does not mean constitution of an atheistic state, but equal status of all religions within the state without favor or discrimination. This, in essence, is what secularism is all about, where the state is independent. It does not identify with any particular religion. Every religion is allowed to flourish. Every religion, every person is allowed to practice the religion of his or her choice propagate it, spread it, of course, within the limitations that are given in the Constitution itself. So this is just to give an expanse of the meaning of the Constitution. Yes, next, of the word secularism.
There's a small question that's come up. Do you want to take it now or later? I can read it out.
Maybe.
Okay.
We can take this easily. It's just a small thing. It was added by Indira Gandhi regime in 1976, okay, during the emergency period. That was challenged by Subramaniam Swamy and several other people. Recently, just less than a month back, after Justice Sanjeev Khanna took over as a Chief Justice of India, he dismissed that PIL, which had been pending for a long time, which said that the word secularism and socialism was not part of the original constitution and that they should be removed. The Supreme Court, the two-judge bench said no, it need not be removed. It's very much part of the life and blood of the constitution, and having it there does not make a difference. So they dismissed that petition. So the basic challenge was that it was during Indira Gandhi's time, emergency period, and therefore it should be removed. Throughout the Constituent Assembly debate, they talked about secularism and socialism as something which is running through the throughout the Constitution, which gives it its life breath. And they said they don't need to necessarily put it as a separate word. Yeah, go ahead, Saira. You were saying something.
No, the question is, why did Indira Gandhi bring it in?
Yeah. She wanted to bring, see, obviously during the emergency time, she did want to bring in by, it goes a lot more into the politics of emergency, which may take us into a different discussion. During the emergency period where they had suspended the Constitution of India, particularly our constitutional right to go to constitutional courts when there is violation of our rights, of our basic rights. That is a time in which the emergency period, that is the worst of the emergency period. That's the time when Indira Gandhi was also trying to show that she's more socialistic than anybody else. And that she had brought in the 20-point program, she had brought in the Garibi Hatao program, and she wanted to move towards a path of greater socialism. And she, for the Congress's particular reasons, brought in that amendment in 1976.
Yeah, I think that was the time of
But
also
that's-
where the wanted the nationalization and
Nationalization
I think
of banks,
yeah.
a lot of nationalization took place at that time, starting from 71, 72 onwards. Okay, so that was a period during which a lot of these efforts were taking place in terms of nationalization, and they wanted to make use of the constitutional provisions to justify why they were doing it, and Supreme Court has also upheld it. Little later, Arvind will take us through Keshavananda Bharati's case, and he'll take us in great detail, I think, in which many of these issues are also covered.
Yeah. Yeah, next slide. Now we're just trying to quickly cover the text so that once Arvind takes over, it will be much more, an intellectual engagement into many of these concepts. Now, coming to the term democratic, political democracy, which means free and fair elections, and also, of course, as far as our country is concerned, universal adult franchise, and rule of law and supremacy of constitution. Rule of law is again a very, very important concept, which I think as we go, we would like to impress upon all of you the importance of rule of law, because the term rule of law, again, as we are looking at the basic structure of constitution, you will find that, that's also one of the concepts which has now been accepted as, fundamental to the Indian constitution as part of the basic structure. But again, rule of law is something which is again embedded in Article 14, that everybody is equal before law and the law will apply equally, and it's not, so that is part of a democratic principles, and to show that ultimately nobody is above the law. So that is and it's not and everybody will be equally governed by law. Ideal of democratic society is reflected through the entire scheme of the constitution, the citizenship, universal adult franchise, fundamental rights. So as I said, again, every concept, every term in the preamble, you would see how it has been expanded in the other parts of the constitution. Yes, and the next. Republic, country is governed as per the constitution and by an elected parliament, contrasted to a monarchy and a dictatorship. Yes, let's move on. Justice goes beyond the procedural notion of justice and envisages justice in social, economical, and political spheres, contemplates dispensation of justice by the executive through policies and orders. So again, when we are talking of economic and social and political justice, now justice is not something which is only something, it's not a notion confined to the states, to the courts. It is not about justice is what judges give. Even as part of the governance process, in terms of enacting our laws, in terms of bringing in our policies, everything is guided by this larger constitutional goal of securing social, economic, and political justice to all. So when we are having, special enactments to protect the Dalits in our country, whether it is SC/ST Prevention of Atrocities Act, or whether it is, reservations for various sections, or any aspect of the matter, whether it is any of the affirmative action, it would all constitute, whether it is through a law, whether it is through its policies, your, NREGA, all of this is oriented towards securing justice in social, economical, and political spheres. So let us not get, the moment the word justice is used, the tendency is to navigate towards courts and law. So here we are looking at justice in a much broader fashion in society. Yes, next. Liberty, equality, and fraternity. The realization of these constitutional goals does not rest solely with the states, it rests with every citizen. They go together, complement each other, and cannot be realized independently. Now, while we will expand on each one of this when we are dealing with the chapters on fundamental rights, because again, Article 21, Article 14, and the rest of it will deal with these concepts in greater detail. But I think what we need to impress upon all of ourselves is that ultimately the goals of liberty, equality, and fraternity is not something out there for the government to achieve for us. Unless each one of us, like we the people of India, unless we the people of India engage in this constitutionalization of our country, to see that constitutional values and constitutional morality is rooted in the soil of our country, then the task is upon each one of us to ensure that we practice the values of liberty, equality, and fraternity in our everyday life, because the goals and values set out in the preamble can be achieved only if such an engagement exists among all the citizens. Yes, Sayantan, next slide. So yes, as I have been stating from the beginning of this session, the social functioning of the preamble, it is not just the social, it's also the legal in every aspect of the way. It acts as the soul of the law. It has an integrative and emotive power, as we have seen during the CAA protests. It has an educational and emancipatory role, as it is in an accessible and easily understood language which people can identify with. I think that is something which all of you will endorse. Some of you, I think, have received those of you who have signed up have received the Constitution copy, the hard copy. And I know one of the reasons why people don't read the Constitution is because the legal language puts you off. And some of the ifs and buts and notwithstanding and the proviso and all these things can, for people who are not used to the legal language, it has a tendency to kind of, make us think that, okay, it's too difficult to understand and we'll put it aside. But the preamble is something which all of us can easily read and identify with. And it is something which actually, as we read, we all get moved. And so there is definitely an emotive power to the preamble. So I think that is a very, and all of us, preamble is, earlier it used to be taught in all schools. I think it used to be in our school calendars, though I don't know how many of us children read today. So it definitely has an educational and emancipatory role, as the language of the preamble is something which every person can easily identify with. Next, Sayantan. Now, we looked at the social function and the legal function of the preamble. Key to understanding the constitutional goals and the constitutional morality. Reveals the source of the constitution, we the people of India, the enacting clause. I will not read the slide, but again, the legal function of the preamble, as I have already explained, that in every argument, as will be explained later, in every case, judges, lawyers, everybody tends to go back to the preamble to lend force to their arguments for either arguing for or against a particular law or a particular provision of law. Because if there is a provision of law which is advancing the goals of the preamble, then yes, it is constitutionally valid because it's taking us closer to the constitutional goals. But if we are finding that it is actually taking away or diminishing, or we are moving away from the from the goal set out in the preamble, then very clearly such an enactment is unconstitutional. So the preamble serves a very important legal function in terms of even interpreting the rest of the constitution and interpreting any other laws brought in by the legislature. Yeah, next slide. We have just given a list of case laws. I will not go into all these in detail because I think as we proceed, many of these discussions may come up because I would like to give Arvind more time because I just thought I'll introduce the text to you so that the more elaborate discussions can happen as Arvind takes you all through other texts. We'll circulate these judgments later on. Yes, Sayantan, we can move on.
At this point in time, there's a wonderful part of Navtej Singh Johar's judgment. If I can put it on the screen here, and maybe just to just tell me how to do it. Just a moment, I'm quite. This one. Are you all seeing it on the screen?
Yes.
Okay. So can somebody read this paragraph? This is from the, I think, Arvind, you can also take over from here. This is from a very important case of Navtej Singh Johar versus Union of India. Can somebody read para 107? Because it's a wonderful, in a wonderful manner, the Supreme Court writes about why preamble is part of the transformative process of the Constitution. It's not just some dead letters or words put together. So could somebody read this?
For understanding the need of having a constitutional democracy and for solving the million-dollar question as to why we adopted the Constitution, we perhaps need to understand the concept of transformative constitutionalism with some degree of definiteness. In this quest of ours, the ideals enshrined in the preamble to our Constitution will be a guiding labor beam. The ultimate goal of our magnificent Constitution is to make right the upheaval which existed in the Indian society before the adopting of the Constitution. The court in Kerala, State of Kerala versus N.M. Thomas, State of Kerala versus N.M. Thomas 1976, observed that the Indian Constitution is a great social document, almost revolutionary, aimed at transforming a medieval hierarchical society into a modern egalitarian democracy, and its provisions can be comprehended only by a spacious social science approach, not by pedantic traditional legalism. The whole idea of having a constitution is to guide the nation towards a resplendent future. Therefore, the purpose of having a constitution is to transform the society for the better. And this objective is the fundamental pillar of transformative constitutionalism.
The next paragraph, next two paragraphs, and then Arvind can take over. Somebody else read this so we can have different voices. Can anyone else read it? If you can see it.
The concept of transformative constitutionalism has at its kernel a pledge, promise, and a thirst to transform the Indian society so as to embody liberty, equality, and fraternity as set out in the preamble of our Constitution. The expression transformative constitutionalism can be best understood by embracing a pragmatic lens, which will help recognize the realities correctly. Transformation as a singular term is diametrically opposed to something which is static and stagnant. Thus, the concept of transformative constitutionalism, which is an actuality with regard to all constitutions, and particularly so with regard to the Indian Constitution, is, as a matter of fact, the ability of the Constitution to adapt and transform with the changing needs of the times.
Okay, somebody else
It is
read
the
the last.
ability.
Can we have some
Sorry.
other voice? Yeah. Can we have somebody else reading it, please?
It is this ability. Please go ahead.
Go ahead. Anyone?
It is this ability of a constitution to transform which gives it the character of a living and organic document. A constitution continuously shapes the lives of the citizens in particular and societies in general. Its exposition and energetic appreciation by constitutional courts constitute the lifeblood of progressive societies. The Constitution would become a stale and dead testament without dynamic, vibrant, and pragmatic interpretation. Constitutional provisions have to be construed and developed in such a manner that their real intent and existence percolates to all segments of the society. That is the raison d'etre for the Constitution.
Thank you. So this is what the preamble does. And every time we read the preamble, every time we interpret the preamble, every time we expand the preamble, we're strengthening the Constitution. Okay. So it's in this context that we need to understand the preamble. There's case laws that we had quoted earlier. We will send you those case laws for any of you who are interested in reading. Arvind, over to you, Arvind.
Sure. Yeah, Shantan, we'll remove the slide. Just a moment.
Arvind, do you want to take them through Article 368 before you move
No,
on?
no, I just want to first remove the PPT. Yeah.
Okay.
Just a little bit of initial comments before we get there, actually. I think the two, both Saila's presentation and Suresh's presentation, were very important in terms of trying to understand the nature, the implications, or the importance of the preamble, which was the point that both of them were making at some great length, as it were. The Suresh's presentation, I mean, just a little bit of context, it'll make a little more sense. Why do we refer to Navtej Johar at all, right? That's the first question. Navtej Johar is a case. For those who don't know, I'm sure some people know, so please forgive us for going over the facts again. But it's a case where you're challenging the constitutionality section 377 of the IPC. What does 377 of the IPC, the then IPC, say? It basically says criminalizes what it calls carnal intercourse against the order of nature, which is all sexual intercourse, which is not penile-vaginal intercourse. That's one way of putting it. But the other way of putting it is what it criminalizes is the intimate lives of LGBT persons. Right? That's the other important framework, as it were. Why this is an important illustration of what Suresh referred to as the transformative power of the Constitution, what Navtej referred to as the transformative power of the Constitution, is because, see, this is not, at my understanding, correct me if I'm wrong, I don't know if I'm in a particularly enlightened bunch of people in this segment. I'm not too sure. All of you will agree that LGBT rights need to be respected. There may be people who don't, not in this space, but generally there'll be lots of people in society who people might agree, right, that LGBT people can do what they want in the privacy of their bedroom. See, the people will tell, okay, fine, it's okay that you're gay. Do what you want in your bedroom. Why you're telling the whole world, right? But Navtej's point is the question of sexual conduct is a question of expression. Go back to the language of preamble. Liberty of belief, thought, expression, faith, and worship. It's a question of expression, right? The question of sexuality is also a question of dignity, right? So there's a question of expression, there's a question of dignity, right? It links to, in a sense, the fundamental promise of the preamble. But again, the language, if you notice Navtej's language, it says that you're challenging what might be hierarchized, if I remember the language, hierarchized traditional forms of society. That's what you're challenging, right? So the point being that the Constitution is, again, the language of Navtej, is a revolutionary document. Why is it a revolutionary document? Because it challenges our mainstream ways of thinking. It challenges our mainstream ways of thinking. So the biases which society may have are challenged frontally by the Constitution. So when we say we the people, the Constitution gives a language to a range of minority groups which may not have that language necessarily in a majoritarian setup. So again, the Constitution is about a constitution protects what you would call a constitutional democracy, not a majoritarian democracy. The difference, of course, is in a constitutional democracy, minorities of all stripes and hues can find the protection under the constitutional shade, right? And so that's the very, very significant point of Suresh getting in the Navtej judgment, right? It's telling us basically that the Constitution and Saila's presentation, which is the idea of the emotive part of the Constitution, or the emotive part of the preamble, and the preamble as a way to transform the relationships between each other, right? That's the very significant point over here, right? So the preamble is no promise, it's a pledge, it's also a document which tells us that, we must transform the way we relate to each other, right? And the way we relate to each other as mandated by Section 377 is to prohibit certain forms of intimate relationships totally, right? And so that is unacceptable within the transformative reading of the Indian Constitution. Keep that in mind, and again, a similar judgment on the adultery judgment with the law, right? The Supreme Court judgment strikes down the provision which criminalizes adultery if practiced by a man, right? Again, the similar point. I mean, if you speak in a wider society, people say, yes, adultery is wrong, of course it should be criminalized. But the Supreme Court's understanding is the adultery law is meant to protect the property of the man, since it's only you can read it in a certain way as protective of the interests of women, but the point is the biases and prejudices underlying the law which need to be challenged. So again, go back to the language which Suresh quoted, the Constitution is a revolutionary document, right? And again, you go back to Glanville Austin, he makes the point that the heart of the revolution, the revolutionary impulse in the Constitution is the fundamental rights and the directive principles. Again, why are they revolutionary? They are revolutionary because the society doesn't believe in these concepts, right? So again, going back again to the other core concept, which links to transformative constitution, is that concept of constitutional morality, right? So the idea that we must transform or change the way we relate to each other is fundamental to the promise or the pledge of the Constitution. So that's why the preamble, in that sense, is a very significant and a very, very important document for us to think through, right? And so from here, I want to go into, again, maybe a little more, as both Suresh and Saila are indicating, a little more detail, the entire question of the amendment of the Constitution, right? And what is the link and why look at the amendment of the Constitution in this particular context? You ask that question, and the answer really gets to the question of, is there something called amendment to the Constitution? Meaning, can you amend each and every part of the Constitution? If, for example, I start amending parts of the Constitution, remove parts of the preamble, remove the equality chapter, remove the freedom of religion, all using the language of the Constitution itself, is that amendment of the Constitution or is it destruction of the Constitution? If the Constitution, right, if you read the Constitution, which we'll put on the screen now, Article 68 provides a procedure for the amendment of the Constitution. Again, you go back, if you remember Ambedkar's, I think, closing speech, where he says that we have dealt with many of the challenges posed before us. One of the challenges, who are you sitting in the Constituent Assembly and drafting a constitution, and you want to rule? He quotes Jefferson there, right? Jefferson, if you remember, right? He says the insolent tyranny wanting to rule from beyond the grave, right? How can you presume in this generation Randan, can we just hold on a minute, please? Yeah. How can we presume in this generation to rule future generations? That's the question which Jefferson's asking, which Ambedkar, in a sense, is paraphrasing as well, right? And the answer over there, which Ambedkar puts forward, is, see, we have laid down a procedure for amending the constitution, which is very simple, right? 368, which I'm going to put on the screen in a minute, lays down the procedure for amending the constitution. Certain provisions amend by a simple majority. Certain provisions you amend by a simple by 2/3 majority and by ratification by state legislatures, by 2/3 of state legislatures. So different procedural mechanisms are laid down. Then the question you can ask is, in Ambedkar's thinking, did he mean then that as long as you comply with the procedure, it's fine. You can amend any part of the constitution. Is that what Ambedkar meant? Is that Ambedkar's concept that yes, it's a very easy to amend constitution. We don't want to rule from beyond the grave. All that is fine. So which means that you can amend any part of the constitution you choose to amend. Is that the question? Right? I'll take you back again to answer this from Ambedkar's viewpoint. Go back to the response, Ambedkar's response to the objectives resolution, right? If you go there, what you get is a certain kind of what he says, right? And though we think of Ambedkar and Nehru sometimes as being on different pages, what Ambedkar says, right? He says that when Nehru moves the objectives resolution, he's not being a socialist. He's just embodying, as Saila indicated, the ideas of the French Revolution. And what's new in that? Even as he puts it, if I remember the language, even in a country as ancient and traditional as ours, right? We have accepted these basic principles. So if you read that, Ambedkar's statement of the objectives resolution, with Ambedkar's statement, again, this is the cross-textual reading. Read that along with Ambedkar's statement in the closing speech. I don't think, my interpretation, I don't think Ambedkar meant that you can amend any part of the constitution you choose to amend. You read again Suresh's reference to the word socialist, right? So, the word secular. Secular is not there. Do you mean Ambedkar is not for secularism? No, his understanding of secularism is woven into the very fabric of the constitution. It may not be expressly stated, but is implied in every segment. Every article of the constitution implies that it's secular. So you can't, amendment cannot mean, again, the word which Keshavananda popularized, or which you have to keep in mind, can amendment mean destruction of the constitution? That's the question which we have before. And let's look at the language in 368. Chandan, sorry, please go ahead and put it. Shall I just share myself? It'll be.
It's ready. It's just loading. Just give me a second.
Oh, it's.
Yeah, I think this is the central thing you were asking, right?
Yeah, just show the text of 368 and then.
Yes. So it's in 3 parts. Let me know which part you want to focus on.
No, I'll tell you what's easier. I'm just going to just look at my text, right?
Okay.
Because just, yeah.
I'll stop sharing.
Yeah. Yeah. Can you see the PPT thingy?
Yes, it's visible. It's visible.
Okay, it's visible. Okay, great. Okay. So, yeah, anyway, the way I titled this is the question of constitutional identity, Keshavananda and his progeny, meaning to say that why does this fit within this presentation framework itself when we're talking about the preamble, right? Because fundamentally, we're interested in the entire issue, what is the identity of the constitution? right? And identity, for all of us who know the question of identity, is always a slightly more abstract question. It's not as concrete as, as I have two eyes, one nose, etc., etc. Your identity can always lead you into slight higher level abstraction, and constitutional identity is not very different. The level of abstraction which the debate unfolds, right, or begins. The big question, the big case on all of this is the Keshavananda Bharati case, and there's a lot of you can ask away, but I'll just make a quick couple of points on this. Is that Keshavananda Bharati was a head of a mutt in Kerala with large land holdings as well, and basically under the 24th and 25th constitutional amendments, a range of those land was sought to be taken over by the state. He challenged that, and the challenge goes up all the way to the Supreme Court. And the question which comes up is the validity of the 24th Amendment, the 25th Amendment, and the 29th Amendment, right? And just wait, let me just get to 368 text, which is what we wanted to get. 1 second. Yeah, you can see the constitution here.
Not yet, Arvind. Have you started sharing?
You can't see it?
Not yet.
Let me just first get the article and then I'll solve this problem now.
Should I share? I have the article in front of me.
I'm doing it.
Okay.
Yeah.
Yes, it's come.
Yeah, great, right? So the only place in the Constitution where the entire question of amendment is mentioned is Article 368, right? And if you read it, 368(1) says, notwithstanding anything in the Constitution, Parliament may exercise its constituent power, amend by addition, variation, or repeal any provision of the Constitution in accordance with later on in this, right? So the idea that you can amend any part of the Constitution is what at least 368(1) ends up communicating. Just 1 second on this. And the language of 368(1) is basically is what the 24th Amendment really introduces, right? So the idea that this overwhelming idea, right? Amend by way of addition, variation, or repeal, right? So it was not the language previously overwhelming character where the basically to say Parliament can do anything it wants, right? Two lays down the procedure of amendment, right? Amendment may be initiated by the introduction of a bill, and when the bill is passed in each membership of that house, majority of not less than 2/3 of the members of the president voting, each president will give assent, and the Constitution shall stand amended in accordance with the terms of the bill. So by and large, very simple procedure amendment. But in case procedure is more complicated, which is 54, 55, Chapter 4 lists, etc. And where the amendment should also require to be ratified by the legislature of not less than 1/2 of the states by resolutions to that effect. Right? So you see the procedure, but look at again, these are way of constitutional amendment. Look at the Article 5, right? Subclause 5. This is again the Indira Gandhi Amendment. For the removal of doubts, it is hereby declared that there shall be no limitation whatsoever on the constituent power of Parliament to amend by way of addition, variation, or repeal the provisions of this Constitution under this article. Right? So you get you see, right? You see 5 and you see 1. Basically, Parliament is supreme. Parliament can do what it wants. So where is the question of of there being any limitation the power of Parliament when you have said that the constituent power of Parliament, it can do any addition, variation, repeal of this constitution in accordance with the procedure laid down in this article, right? So you can do, there's no limitation on what you can amend as far as 368.1 is concerned. And 368.5 you read, then you're like, wow, the removal of doubts is hereby declared. There shall be no limitation whatsoever on the constituent power of Parliament to amend by way addition, variation, or repeal the provisions of this constitution under this article. So basically, if you read these two provisions, 368.1 and 5, right, you get a sense that the judiciary may not have much of a role. Parliament is supreme. That's the understanding you get from the provision 368.1 and 5, right? And the judiciary, of course, then faces a fundamental challenge to its strength, to its legitimacy, to its power, as it were. And the judiciary answers this question of the power of Parliament in the most fundamentally, most importantly, in the Keshavananda Bharati case, right? And that's the case which we'll go through. And in Keshavananda Bharati, again, it's a 13-judge bench decision, so the largest bench ever constituted by the Indian Supreme Court, and it's a massive judgment, and finally you get a majority of 7:6, right? And 7:6. Let's before we get into the majority of 7:6, let's look at what the arguments of the petitioners were, what the arguments of the respondents were. Before that, again, make the case that all the key figures, right, in Indian judicial history at the time were involved in the arguments. Palkiwala was arguing the matter, Sirvai was arguing the matter. So range of really, at that moment in time, very big or very important lawyers, constitutional lawyers, were involved in this matter. Of course, this is the core issue, right? Why is it a core issue? Because Parliament has asserted it's almost untrammeled on complete power. So what does the judiciary do in that particular context? That's the question which you have before you. And let's see how the judges frame it. One second. Yeah. Simple question. What is the issue of the amending power conferred by Article 368 of the Constitution of Parliament? That's a question which we really want to look at, right? So can you amend away the entire Constitution, or the several limit points on what is amendable, as it were? And what are the arguments, right? Arguments before the court, right? The arguments of the respondents, which are in this case Keshavananda Bharati is the petitioner, the respondents is Union of India, right? And the Union of India claims, the respondents claim that Parliament can abrogate fundamental rights such as freedom of speech and expression, freedom to form associations or union, and freedom of religion. They claim that democracy can even be replaced and one-party rule established. Indeed, short of repeal of the Constitution, any form of government with no freedom for the citizens can be set up by Parliament exercising its powers under 368. Again, very, I think, chilling in some senses, but also very interesting, I thought, interpretation, right? You're interpreting that particular Article 368. You're saying that, let's get shorn of all this great philosophical notions, etc. 368 gives you the power. It doesn't say you can't repeal or amend. It gives you the power to repeal and amend. So what's the problem? We can do what we want under 368. That's this argument. Of course, underlying it is the argument that actually it's a parliamentary democracy and Parliament is supreme. Why should the judiciary exercise any power or any check on what is a legitimate organ of the state, which is elected by the people? The judiciary anyway, right, suffers from a democratic deficit. They're not elected. 5 people sitting somewhere, which is that Ambedkar's language, if you remember, 5 people sitting somewhere. Why should they have respect? That's the argument as far as the respondents are concerned. Okay, then one more, we can just read what Shailat and Grover as well say on the Shailat and Grover, the Justice Shailat and Grover again.
Arvind, there's a small
some-
question that's come up. Can we take it now or later?
Can we just, yeah, what's the question?
So why did this case demand a 13-bench judge? How did it gain so much importance?
Yeah, okay, that's a good question. The way this evolves, right? You have 5 judges, 7 judges, 9 judges, and then if you have 11 judges, then the only way to get past 11 judge is 13 judge, right? So there's a certain history of litigation. All of the history of the litigation is around the entire question of the constitutionality of the land reform legislations. And the previous decision in Golaknath, right, was sought to be overruled by Keshavananda, right? So Keshavananda filed a petition, right, to say that there's an 11-judge bench judgment, which we're not in agreement with. Right? And completely different fact situation. So he files a petition, and the court constitutes, right? The Chief Justice constitutes a 13-judge bench to decide this matter, right? And again, because it's land reform. It's the question of constitutionality of the land of those 2 amendments. That's one part of it. But underlying it, if you look at it in a more abstract sense, is the question of what is the power of Parliament and what is the power of the judiciary? That's the core question, right? And so obviously it's a question which is linked to the very, very fundamental part of the nature of what should the nature of the Indian state be, right? And finally, it gets to the 13 judgment. Could it have got bigger? Again, it's a good question. It could have got bigger. You could have got to the full. You could have got all the judges in the Supreme Court, right? You could have got a bench that size as well. And there was an attempt, right, after this to overrule Keshavananda by constituting a bench of larger strength. But then there was so much opposition that finally the Chief Justice at the moment in time dissolved the particular bench, right? So the benches, yeah, you can get a larger bench if the Chief Justice so decides on the particular question. Yeah. Anyway, let's get back to the question of the respondents again. Just repeating this actually. Respondents, just see how overwhelming the argument is, right? The respondents, on the other hand, claim an unlimited power for the amending body. It is claimed that it is the full constituent power which a legal sovereign can exercise, provided the conditions laid down in 368 are satisfied. I can see it's a kind of a simple point. 368 lays down procedure, we'll comply with procedure. Other than that, we're legal sovereign. We don't need to comply with anything else. We're full constituent power. The content and amplitude of the power is so wide. If it is so desired, all rights contained in Part 3, we won't read the rest, can be abrogated and taken away. Okay. What is the argument of the petitioners, right? On the petitioners, this is Keshavananda Bharati and others, it is maintained, among others, inter alia, that the power of the amending body Parliament under 368 is of a limited nature. The Constitution gave the Indian citizens the basic freedoms and a polity of form of government which are meant to be lasting and permanent. Therefore, the amending power does not extend to alteration or destruction of all or any of the essential features, basic elements, and fundamental principles of the Constitution, which power, it is said, vests in the Indian people alone, who gave the Constitution to themselves as it is stated in its preamble. Again, go back to Silas spending time in the beginning on we the people, right? So the question of legal sovereign, all very well, right? But the legal sovereign is, end of the day, is also, right, is also draws its power from the question of the preamble. So you're a legal sovereign, but you're under the Constitution. You're not over the Constitution. A legal sovereign cannot destroy the Constitution under which it is constituted, right? So you're a executive or you're a legislature. You're a body constituted under the Constitution. So if you're a body constituted under the Constitution, can you destroy the Constitution? Can you claim the kind of power to destroy your own? Who gave you your identity and your powers? So can you be in a sense, a Frankenstein's monster, which can escape the limits imposed by the Constitution itself, right? And so the language being used over here is that the Constitution gave the Indian citizens the basic freedoms and a polity form of government to meant to be lasting and permanent. Goes back to again what Mr. Kannabrand's argument is, that the Constitution does not confer rights, it merely confirms them, right? So there's a way we the people have certain rights which a legal sovereign can't now claim that we're taking it away. That there's a so you get the very, very important question which the petitioners are raising. And what is the legal argument over here? They're saying that, sure, you have the amending power, right? Sure, you have the amending power, right? But the amending power, the word amend is to change or to change. It's not to destroy, right? It's amendment, destruction. That's the question being raised by the petitioners, right? And what do you mean by destruction? Destruction of the essential features, basic elements, and fundamental principles of the Constitution, right? Which power vests in the Indian people alone who gave the Constitution to themselves, right? So that's the petitioner's argument, as a summary by, again, Justice Shilatan. Then we'll look at some of the majority opinions in this case, right? Justice Sikri's opinion, he says, I must interpret Article 368 in the setting of a Constitution, in the background of a history, and the light of our aspirations and hopes and other relevant circumstances. No other Constitution in the world is like ours, and need hardly observe that I'm not interpreting an ordinary statute, but a Constitution, which, apart from setting up machinery for government, has a noble and grand vision. The vision was put in words in the preamble and carried out in part by conferring fundamental rights on the people. Again, you get a sense of why this is so closely linked to Suresh and Saila's presentation in the first part, right? Because the point being made here is the preamble in a Constitution is very, very different from a preamble in a statute. Because the preamble in the Constitution, you have to think of it in the question of the background of history, light of aspirations and hopes and other relevant circumstances. Here, of course, I mean, without doubt, if you read about it, you can imagine that they would have referenced the objectives resolution in great detail, and they did. They did, right? They referenced the Nehru speech in great detail. The Ambedkar speech as well, I think they referenced, right? So to get the question of, you're saying, hey, Article 368 is there. It's not a standalone article. To interpret Article 368, they're saying, yes, it confers the power. Justice Sikri's opinion, he says you can't do that. You have to interpret it contextually. You have to interpret Article 368. You can look at the word interpret. You interpret 368 in the setting of the Constitution, in the background of the history, and the light of aspirations and hopes and other relevant circumstances, as broad as that, right? And says that you're referencing particular the vision which is there in the preamble and carried out in part by conferring fundamental rights on the people, right? So there's the way in which you think of it, right? The way you interpret a statute is very, very different from the way you interpret a constitution. To interpret a constitution, history or background is very important, for which, of course, which is why it's such a 500 pages plus judgment. They go in detail into the question of the making of the Constitution, and reference in particular, of course, the objectives resolution. Okay. This, I think, is useful to read only so you get a sense of Justice Sikri's opinion continuing, right? And this is a brief summary. The summary is not here, of course, you read the whole judgment for that. The above brief summary of the work of the advisory committee and the minority subcommittee shows that no one ever contemplated that fundamental rights pertaining to minorities would be liable to be abrogated by an amendment of the Constitution. The same is true about the proceedings of the Constituent Assembly. There's no hint anywhere that abrogation of minority rights was ever in the contemplation of important members of the Constituent Assembly. Seems to me that in the context of the British plan, the setting up of minority subcommittee, the advisory committee, and the proceeding of these committees, as well as proceedings in the Constituent Assembly mentioned above, is impossible to read the expression amendment of the Constitution as empowering Parliament to abrogate the rights of minority. So one interpretation which Justice Sikri does here is saying, what about the question, if you say you can amend any part of the Constitution, what about the rights of minorities? His argument is you have to interpret that in the light of what is the constitutional history, right? And again, this is just a technical point which you should note, is the among the committees, which again was referenced in the first part, among the committees by the Constituent Assembly, one is the advisory committee. The advisory committee has a subcommittee on minority rights and subcommittee on fundamental rights, right? And Justice Sikri's point here is you read, I mean, this is all there. This is again Professor Bakshi's point. He says that, if you want to understand the Constitution of India, you have to read Keshavananda Bharati, not one time, but 50 times. Right? That's his point. At the time, we might not go that far, but the point is very important. To understand the Constitution, it's very useful, right? Because again, what gives life to the Constitution is these judgments. It gives you a better understanding of what the Constitution means to say, what the Constitution does, right? And so for example, you'll get a sense, right, of the work of the advisory committee, you'll get a sense of the minority subcommittee, and you'll get a sense of how this, in Justice Sikri's opinion, that the entire question of minority rights is woven into the texture of the Constitution, and at no point in time do any significant members of the Constituent Assembly or any of the committee reports ever contemplate the abrogation of minority rights. First, you get his concluding comment that it is impossible to read the expression amendment of the Constitution as empowering Parliament to abrogate the rights of minorities. So you get a sense of, you read in a limitation, right, to the power of amendment based upon a reading of constitutional history. And okay, this is the final point on Justice Sikri's opinion. We have seven judges in majority opinion, but the other are 2, 2, and 1. Yeah, the Justice Sikri, who's I think Chief Justice Sikri's opinion is basic structure of the Constitution, supremacy of the Constitution, Republican democratic government, secular character of the Constitution, separation of powers, federal character, and he says the above structure is built on the basic foundation, the dignity and freedom of the individual. This is supreme importance. This cannot by any form of amendment be destroyed. Right? Again, very, very interesting, right? In terms of the way the articulation is happening, right? Again, goes back. It's interesting, right? That right? This entire question of what we discussed in terms of should dignity come first or unity and integrity of the nation come later. I'm trying to remember again because I haven't read the judgment 60 times. Whether it is referenced in Keshavananda Bharati. Somebody please, with a constitutional interest in this point, please maybe look at that very simple point and get back in next class. Just Justice Sikri reference the entire question of should the word dignity come before the word unity and integrity of the nation. That is, of course, the reference to B.N. Rao's argument in the minority subcommittee. Since he's referencing the minority subcommittee, I'm sure he's referenced it, and now I can't remember. But somebody please look that up and get back next time. We'll see if because it'll also be useful for you to read a little bit of the text, I think. And in fact, going through this presentation is that you're saying please read the text yourself, right? We're only giving you a small insight, right, into what the text is actually containing. The above foundation and the above basic features are easily discernible not only from the preamble but the whole scheme of the Constitution, which I already discussed. So again, it's very interesting. It arrives at these 1, 2, 3, 4, 5 points based on looking at the various subcommittee reports and looking at statements by prominent members of the Constitutional Assembly, and he's able to derive what he calls the scheme of the Constitution. So this point we have already made. Okay. the final conclusion, of course, is the expression amendment does not enable Parliament to abrogate or to take away fundamental rights or to completely change the fundamental features of the Constitution so as to destroy its identity. Within these limits, Parliament can amend every article. Again, very important. Basic structure document is not saying you don't have the power to amend. It's saying you have the power to amend completely. Of course, 368 gives you the power. But what you can't amend is those features which are part of the very identity of the Constitution, right? What are part of the identity of the Constitution. So again, there's a very important question, which the Jacobson piece in a sense references. What do you mean by constitutional identity? How do you know what is the identity of a constitution? What is the level of abstraction which you think of the question of constitutional identity, right? Let's see if we can answer that question in some ways through some of the other case law. Okay, let's look at Justice Shelath and Grover, which are the other two judges who are in the majority, along with Chief Justice Sikri. Shelath and Grover say the basic structure of the Constitution is not a vague concept, and the apprehensions expressed on behalf of the respondent that neither the citizen nor Parliament would be able to understand it are unfounded. Again, see, if lawyers will often say, right? You say basic structure, what a vague concept, right? You say constitutional morality, what a vague concept. You say dignity, what a vague concept, right? And the answer to that, as far as Justices Shelath and Grover are concerned, is it's not a vague concept. There's nothing vague about the basic structure, because if you look at the historical background, if you look at the preamble, if you look at the scheme of the Constitution and the relevant provisions, including 368, there's no difficulty in discerning that the following can be regarded as the basic elements of the constitutional structure. Again, they cannot be catalogued, can only be illustrated. Right? They're trying to see the question of identity, and to keep it a level of abstraction. You can't make it too concrete, right? Because you make it too concrete, then you fix it. Again, there's a very, very nice, in fact, in the judgment itself, I think, I don't know if I've got it here, but Justice Khanna says the concept of liberty cannot be fixed in unalterable law. If it's fixed in unalterable law, there's a way in which the life of the concept goes, right? So there's a way in which you have to have a certain level of abstraction about concepts, right? And that's the identity part. When the identity is linked to the level of, when you're tracing it or placing it at some level of abstraction. Here, of course, the Shelath Grover point is simple, that you understand basic structure in the context of historical background, preamble, scheme of the Constitution. So again, you get a sense of why we reference so strong background, but it's very important. You can't understand this document if you don't know the historical background. And you can't understand the question of what might be the basic structure, or you can't answer questions when people have questions of basic structure if you don't have the question of the background of the document, which means that you read far more extensively in terms of the constitutional history, right? Then Justice Hegde and Mukherjee, who also put forward a joint opinion, again in the majority, where they say every constitution is expected to endure for a long time, therefore necessarily be lasting. It's not possible to place society in a straitjacket. Straight is very badly spelled. In a straitjacket, the society grows, its requirements change. The constitution and the laws may have to be changed to suit these needs. No single generation can bind the course of the generation to come. Hence, every constitution wisely drawn up provided for its own amendment. Right? Starting point, they seem to be taking the viewpoint that yes, of course, it's expected to endure, but society grows, requirements change. So, of course, you have to have a way of amending the particular constitution. In other words, one cannot, but the final conclusion is, in other words, one cannot legally use the Constitution to destroy itself. Under 368, the amended Constitution must remain the Constitution, which means the original Constitution. When we speak of the abrogation or repeal of the Constitution, we do not refer to any form, but to substance. If one or more of the basic features of the Constitution are taken away, to that extent, the Constitution is abrogated or repealed. If all the basic features are repealed and some of the provisions inconsistent with these features are incorporated, cannot still remain the Constitution referred to in Article 368. Very important language. And again, it gives you a way to think, right, of the entire question of, of amendment and repeal of the Constitution. When Suresh referenced a little earlier, the recent Justice Khanna judgment on secular and socialist, right? The question to ask is not the point whether you can amend the preamble. The answer to the question on the Bharat is concerned, of course, you can amend the preamble. There's no problem there. But in your amendment of the preamble, are you taking away the basic feature of the Constitution, or are you putting in place, are you incorporating features which are inconsistent with the Constitution as it stands? And Justice Khanna is very interesting. It says that the word secular is not inconsistent with the Constitution. It's not introducing an element which is outside the frame of the Constitution. It's not challenging the nature or the feature of the Constitution. The word socialism, again, is not. Again, there's an interpretation he gives of socialism. He says socialism is not what you think it is. It's in India, it means a welfare state, right? And so welfare state is very much within the frame of the Constitution, right? So the Justice Hegde and Mukherjee's opinion is clear that of course you can amend, but amendment cannot mean abrogation or repeal. And if it's the basic features, you take it away, it will mean amendment or repeal. Jagan Mohan Reddy's opinion I'm not going to go into, but Justice Khanna finally puts it very, very eloquently. He says the provision regarding the amendment of the Constitution does not furnish a pretext for subverting the structure of the Constitution. Nor can 368 be so construed as to embody the depth of the Constitution or provide sanction for what may perhaps be called as lawful harakiri. Such subversion or destruction cannot be described to be amendment of the Constitution as contemplated by 368. Again, you got the point by now that amendment is, in Justice Khanna's language, cannot be the death wish of the Constitution, right? You can't say 368, right? Provides a procedure to amend, but 368 cannot be construed to embody the death wish of the Constitution. You can't use 368 to kill the Constitution itself, or to commit what might be called lawful harakiri, right? Such subversion or destruction cannot be described as amendment, right? Because amendment is a term. It's not destruction. So amend and destroy are very different terminologies. So what's the time? We have 9:30. Okay. So let me maybe if anybody has any thoughts on this, maybe we can take a couple of thoughts or discussion, whichever way to
One
whichever way you.
way, Arvind, is if we could break ourselves into two groups or three groups. There are 33 people, and they discuss in each group. You can be in one, I can be in one, and Saila can be in one. And we discuss what we had discussed now. What do they think about the preamble? What does it make sense to them? How? Unless, if there's any other question that you would like to pose for each of the three groups, we could take that also.
There's one suggestion. If we can just open it for all the people over here in the plenary. If anybody has a question, then anybody can listen to the answers. If there's no question, then we can break out. Is that okay?
Sorry, I didn't understand, Shantanu.
No. So right now, whoever is there, if anybody has a question right now, let it be posed and answered. If there are no questions, then we can break out into rooms and then discuss generally. Yes.
Yeah, no. I also have some more points. I mean, which I wanted to cover, but we can leave that. I can just share this slide.
No, let Arvind finish.
The later part of it.
Suresh, let Arvind finish his presentation. I think he's just paused it here, isn't it?
Yeah. No, I was wondering. I mean, so we can go either ways, whatever way you guys consider might be the best way forward. Either we can have a discussion, point one, we can have a plenary discussion, or the third point is I have a little bit more on the question of how basic structure was applied in a couple of cases. That might just be useful to finish the discussion. That's the only point.
Yeah, sure. And maybe then open it up for larger discussion.
Yeah, I just hope that we have time for discussion after that, but yeah, I'm going to try and play as I can.
Go ahead then, Arvind.
Yeah. Okay, so see the Keshavananda Bharati again is it's a very brilliant, how do you say, judgment in terms of strategy as well, right? Because in effect, right, the judges hold the two constitutional amendments valid. While at the same time, they have a basic structure doctrine saying that what can't be amended. So 24 and 25 comes within the frame what can be amended, right? So you look at it and say, I mean, if you were there and you were arguing that matter, you'll be like, oh, all the song now, they said all the beautiful things. End of the day, we're not going to relief. That'll be a point, right? But what they do is they open the door to the future. Right? And so that's why the second part is very important, actually, in terms of what Keshavananda Bharati does not, in that judgment, is not very little. But what it does for the future of of constitutional law in the Indian context is very important, right? And so that's the second part of it, which is quickly, well, I'll try and quickly go through it, which is okay. The minority judges I can just one line summarize it, which is the rights are a gift of the Constitution. That's their frame, right? That's their frame. Then the following judgments, right, in terms of the Indira Gandhi versus Rajana Rai, where just again, if you very, very quickly read this, is on the entire question of again a constitutional amendment which Indira Gandhi brings in, which under 329A, right, which abolished the forum for adjudicating a dispute related to validity of an election on the ground that the particular article introduced by constitutional amendment violated the principle of free and fair election is. Okay, not explaining this very well. Okay, let's put it this way. Article 329A, right, basically said that if there's any dispute with respect to the election of a speaker or the election of the prime minister, the courts cannot adjudicate upon it. Right? That's what it said. Right? And so what happens in Indira Gandhi is Justice Khanna strikes down that amendment, saying that you can't abolish the forum. Why can't you abolish the forum for adjudicating on a dispute related to the validity of an election? On the that the particular article which is introduced by constitutional amendment violated the principle of free and fair elections, the essential postulate of democracy, which was in turn is a part of the basic structure of the Constitution. Right? So he basically strikes that clause down, saying that it violates the principle of free and fair elections, which is the essential postulate of democracy, also part of the basic structure. So you get a point of how Keshavananda gets used in Indira Gandhi. Right? Matthew also struck down the article on the ground that damaged the essential feature of democracy. Justice Chandrachud reached the same conclusion by holding that the provisions of the article outright negation of the right of equality conferred by Article 14. As far as amendments made to the preamble for the second amendment illustration of the scope of the amending power, the case last referred to affords an illustration of the limitations on the amending power. See, again, this is a great point over here. The final point. Again, what the bench is saying is amendments by itself is not a problem. Right? Amendments you made to the preamble is an illustration of the scope of the amending power. Of course, you're entitled to amend and say socialist and secular. There's no problem because you're not destroying and damaging the fundamental features. But the case last referred to, which is this case, affords an illustration of the limitations on the amending power. One is amendment as maybe explicating on values, and second amendment as destroying the Constitution, and that's what can be struck down, right? And that's in the Indira Gandhi case. Okay, I think we leave this. I think we don't have time for that. Minerva Mills is the other judgment, where again, which talks of the balance between the directive principles and fundamental rights. And let's just read what Justice Chandrachud had to say. Since the Constitution has conferred a limited amending power on Parliament, the Parliament cannot, under the exercise of a limited power, enlarge that very power into absolute power. Indeed, a limited amending power is one of the basic features of a constitution, and therefore the limitations on the power cannot be destroyed. In other words, Parliament cannot, under 368, expand its amending power so as to acquire for itself the right to repeal or abrogate the Constitution or to destroy its basic or essential features. The donee of a limited power cannot, by the exercise of that power, convert the limited power to unlimited one. Again, simple point. Parliament is constituted under the Constitution. Therefore, its power is limited, and the limited power cannot be converted into an unlimited power because you're a donee of power, and you have to work within the framework that you have, and you cannot destroy the basic or essential features, right? And the key point he's making, of course, is the balance between the directive, the fundamental policy, and the directive principles and the fundamental rights. And as he puts his last line only, anything that destroys the balance between the two parts will ipso facto destroy the essential element of the basic structure of our constitution, right? So that's Minerva Mills on the link between directive principles and fundamental policy, and Indira Gandhi on the democracy as a fundamental feature of the constitution. And the last judgment which I'll refer to, we won't go into Bhagwati's opinion on this, is the Janhitt judgment. Janhitt again is the EWS judgment, and the EWS judgment is basically the constitutional amendment which uses
that's the economically weaker section.
Economically weaker sections, and the dissent in this case was Justice Butt and Justice Lalit, right? And the dissent takes you again to the question of constitutional identity. The simple point they make, again, that the EWS, the problem with the EWS judgment in the opinion of the minority, I don't think we need the screen immediately. The problem with the EWS judgment in the opinion of the minority is that what it does is you exclude.
Arvind, very briefly, if you can just say what the EWS thing is.
Yeah, the EWS is the reservation of economically weaker sections, right? And it's a constitutional amendment which provides for reservation in educational institutions for economically weaker sections, and that's the nature of the amendment. Now, most government institutions implement EWS reservation. The only problem, of course, is who are the economically weaker sections? We know, I mean, through both factually and through historical material, etc. The economically weaker sections overlap with the scheduled castes, the scheduled tribes, and the minorities. But what the EWS says, the EWS amendment says, is the EWS reservation is only for those who are not scheduled caste, scheduled tribes, and OBCs, right? So the minority opinion basically says that when you exclude scheduled castes, scheduled tribes, and OBCs from the benefit, from the entitlement to EWS reservation, you're striking a really fundamental feature of the Constitution. The Constitution, in effect, says we don't discriminate on grounds of caste, religion, status, etc. And what you're doing by excluding these groupings from benefiting from the EWS reservation is you're discriminating against a group, against these groupings. And discrimination and prohibiting discrimination is the heart of our constitutional order. And it's a part of our constitutional identity, right? Justice Butt goes to the extent of saying that our constitutional identity is on grounds of caste, on grounds of religion. And here you have constitutional amendment which expressly, overtly discriminates against these groupings. They are the poorest in our society. And you're saying they're not entitled to benefit from the EWS reservation. Right? So there's a way in which, again, constitutional language enters the picture. I'll just read the last section from this before I hand it over to Suresh. Our constitution does not speak the language of exclusion. In my considered opinion, the amendment with the language of exclusion undermines the fabric of social justice and therefore the basic structure. Actually, it's very strongly. I mean, I think you read the whole part. I regret my inability to concur with the views expressed by the majority opinion on the validity of the 1/3 constitutional amendment, since I feel, for reasons set out elaborately in the following opinion, that the court has for the first time in the 7 decades of the Republic sanctioned an avowedly exclusionary and discriminatory principle. a constitution does not speak the language of exclusion, in my considered opinion, the amendment language of exclusion undermines the fabric of social justice and therefore the basic structure. Of course, we can think of the CAA amendment. Again, we can think of that as speaking the language of exclusion, and arguably the but minority as well as Keshavananda Bharati will be useful arguments one can put as and when and if and when that matter comes up for adjudication, right? And one last paragraph from here. Okay, this last line. To conclude, the theory of basic structure is based on the concept of constitutional identity. The basic structure is a preoccupation constitutional identity. That's just Bhatt's final conclusion, right? So the end of the day, when you strike down a provision as violating the basic structure, right? It's not just that it violates a provision; it violates something which is your very identity. It's who you are, right? You don't discriminate, and if you discriminate in a constitutional amendment, it strikes something so fundamental that it should be struck down as violating the basic structure. Right? So basic structure and constitutional identity are very closely or intimately very closely linked to Justice Bhatt's point. Okay, he has some more very wonderful lines, but I think we'll stop with this. I think you can read the rest yourself. Yeah, fine. I'll share this later on. Yeah.
Thanks, Arvind. In the minority ruling in the EWS case, for those of you who may not have followed that discussion, this was an amendment brought about recently, about 2 years back or 3 years back, where they said that they kept aside 10% for the economically weaker sections, and then they said they excluded weaker sections from SC, ST, and OBC, as Arvind had said earlier. It took me some time to understand what the whole issue was. So when the issue came up in the court, and the court was asked to say, can you exclude Dalits, SCs, STs, OBCs from the 10% reservation? The government said they have to be kept separate because it has to be only for the other castes. Then the whole issue came up before the court saying, for the reservation, affirmative action for the various communities in the car is for historical reasons of discrimination and not economic relations. So the basic structure they said was that it was to address historical injustice, for which Article 15, Article 16, and other things were giving reservation, what we call as reservation. Now that has not been provided. Economic thing has not been provided in the Constitution. This was overruled in the sense it is a minority opinion and not a majority opinion. Okay, we'll have to see what comes in the future on this. Okay. So it's over to the quorum for discussion.
Before that, can I just ask a small question related to this topic?
Yeah, go ahead.
No, so my question is that, for example, reasonable classification in, say, Anuj Garg case or whatever, so that also uses some criteria to not exclude, but to differentiate between two groups and then afford some advantage to another group. So how does that reasonable classification doctrine also sort of merge with this exclusionary thing which Arvind sort of pointed out? And is it applicable only to sort of cases where affirmative action or privileging the unprivileged sort of comes in? Or are there applications elsewhere also?
No, are you saying that it is excluding is part of, will it fall under the reasonable classification, is it?
Or the relationship between these two concepts essentially. And what cases or what sort of circumstances differentiate which will come up?
Okay, I mean, that may take the discussion away from the current discussion because you're going into Article 14 and how reasonable classification is also always clubbed with the objective it seeks to achieve. So by excluding SC, ST, now what is the object that you're seeking to achieve is a question that we need to raise. So maybe we'll defer that question. We'll discuss it further when we are discussing Article 14.
Vinay had a question. Go ahead, Vinay.
Yeah, regarding this argument of inclusion of secular, there was a point in time when we were discussing like, okay, let's concede that and say accept that okay, let secular be removed. The argument was that for inclusion was that it's anyway part of the basic structure. It did not alter anything. The inclusion did not alter anything. Similarly, shouldn't exclusion also not alter anything? Does that argument hold water at all? Given there was a chance that seriously we could have seen such an amendment to remove it, and some of us were thinking that okay, could we just fall back and say that it's, if the inevitable happens, could we still argue that we still have a secular constitution?
When was it, Vinay? I mean, the argument is simple, right? I mean, if you look at the Keshavananda Bharati, Minerva Mills, you can, you have the power to amend. Parliament has power to amend. That right exists with Parliament. But what they can't amend is basic features of basic structure. That's a simple point. So if they can, there's no in this law, secular and socialism, that's the power Parliament has. There's no problem with that.
No,
And,
I think the question that he's saying is, since we have now been contending that anyway secularism, nobody is disputing the power of the Parliament to amend. As a political debate, when people were opposing the inclusion of secularism, saying that it was only introduced by Indira Gandhi and so it should be removed now. And some were thinking, why not? Okay, let's remove it, because if inclusion didn't make any difference because it anyway existed, if you remove it, also it shouldn't make any difference because anyway it is there. But I think I would look at it a little differently, because when the Parliament very specifically and consciously excludes a word, see, we are in a different footing. It's like, I'll just give you an example, a parallel example from labor law, which is in Excelware, where the argument was that, everybody has a right to, under Article 19, we all have a right to practice any trade of your choice. And the right to do business or to carry on any trade includes the right not to carry on the trade also. You cannot compel somebody, you must set up an industry in this area. You cannot compel somebody to run a business. So that was the argument that was in the context of whether industries can shut down, can close factories, because that is with regard to the provision in the Industrial Disputes Act, where under Section 25O, you need to get the permission of the government before you can close a factory. So the argument was, my fundamental right to run a factory includes the fundamental right not to run a factory. But the Supreme Court then, distinguished by saying, while yes, the fundamental right not to run is also part of it, but having acted upon your right to start running an industry, you cannot equate the shutting down of an industry in the same way as not to start an industry altogether. Because once you have started an industry, then certain other rights flow. So they kind of take that argument. Now, drawing a parallel, when the Parliament specifically has exercised its mind and specifically excluded secularism, then the next limb of argument will be, then the intention of the Parliament was to remove secularism from the basic structure or from the preamble of the Constitution, and so you cannot interpret the other provisions of the Constitution as being similar to secularism, because very consciously and deliberately Parliament has removed the word. So having included, removing it, while yes, there is still room to argue, we would still be on a weak wicket, because if somebody has very consciously said, no, we are removing secularism, what does it mean? It means that as a nation, we don't subscribe to being a secular country. So that argument is also very plausible, and so we cannot equate not including at all to having included to remove it. So I think that is a distinction we need to understand.
Thanks, Shaila, for that example. A lot of food for thought. Thank you.
So I have a question. So I think going back to this preamble or the basic structure when in conflict is great. But so I think today a lot of such conflicts come when there may be two different rights have conflicting each other, right? So maybe my right to express and somebody else's right to practice their religion. And that is the argument, right? So which then triumphs over what? So what do we go back to when any two such rights or I think come against each other?
Well, I think, I mean, it's not only in religion. I think in respect of anything, we are living in a situation of what we call competing equalities. I think there is a book also written on the whole issue of reservation. So any aspect that you take, we are always jostling for, there is a competing, rights everywhere. It's not just in terms of practice of religion. Even in terms of education itself, your engineering seats, the right to education is there, but we are still competing. Some people get admission, some people don't get admission. So now the whole thing is, how do you balance in respect of our resources? And for very direct assault on somebody's rights, I think the limitations are provided in the Constitution itself, where the state can intervene in certain situations to protect or place limits on your right. For instance, when we go into Article 19, it will tell you the limitations. I don't know if you have, there is a very famous, in all law college books have carried, one person is walking on the road swinging an umbrella, and there's a lady walking right behind, and the umbrella hits the nose of the lady. So the lady complains. So the man walking in front says, well, I have a right to swing an umbrella and walk on the road. So she says, your right ends where my nose starts. So of everything, you could say that there are always, there are competing rights. But we as a society, then how? That is why when we are looking at the preamble, we are saying that ultimately the constitutional values and ethics should be rooted in each one of us. Because your right to liberty is curtailed if the people around you are big rowdies and bullies. Where is your liberty then? So it's for each one of us to respect those liberties. We all need to respect the other person's rights. We need to be fraternal with each other. We need to believe that all of us are equal. We will treat each other with respect. So that is why the responsibility on each one of us to ensure that we not only protect our rights, but we also create a society in which we all protect each other's rights. Because none of us are living in isolation. We are all social animals. We are all living in very different, dynamics are constantly at play. So that is why we are a civilization. How do we call ourselves civilized? We are civilized only because we think that might is not right. We feel that even the weak need to be protected. So why do we believe in all these things? Because we believe that as humans, we have evolved beyond the animal world where might is right. So that is, I think, the whole issue of the preamble, and which is what, again, going back to the text that we have read, whether it is Objectives Resolution or Ambedkar's speeches, where he says that this constitutional values will have to be rooted in the soil. So it's for now for each one of us to recognize the rights of the others.
And the protection of the weaker sections is not arising from the fact that, from a social work perspective saying I should protect you, but because they have a right. They have a right to be protected. Now, Shivram, the issue of, for example, right to start an industry and the right not to have a polluting industry in your area. These are competing rights. Okay. One may say, I want to start a chemical factory. That's my right under the fundamental right of occupation. Somebody else will say, no, by doing this, it's going to be polluting my area, my water, my air, etc. So when these rights compete or contend or confront each other, the Constitution becomes a basis for which you look at how do you balance these competing rights. Their fundamental freedoms on one side and the directive principles of state policy on the other side. Okay, so that's how you do this balancing, and that's what the Constitution says, which is why in the quotation we read earlier, it's a balancing in terms of enabling society to be more just, fair, equal, etc. There you go back to the preamble. And we need to be able to talk this language in our day-to-day life, when in our writings, in meeting authority, in confronting various decisions that are being made.
Because we are always given this binary, this or that. It's never a binary. You know, we are in a pluralistic society. There are so many competing interests. So if the moment you talk about women's rights, or what about men? You are giving, you know, it gets so ridiculous. You know, reserve seats for women. Oh, why no seats for men? You know, I mean, these are the kind of arguments which take you nowhere. So how do we then see the larger, you know, picture? So that is, I think, that is what each one of us have to keep in mind. And this whole thing of, you know, juxtaposing, you know, different pockets and sections of society against each other. You know,
And
one
just to
versus
tell you,
the other.
and just for all of you to know, these are not empty discussions we are talking about. In Jharkhand, many of the Adivasis in that area are saying we are not Hindus. They're calling, they go back to their own tribal identity in terms of a religious thing and say, we in the census or in other things, you cannot put us, bracket us into the Hindu category. Same thing is happening, for example, in Manipur. It's happening in the Northeast. Okay. So this competition between these things about wanting to include, not wanting to include, is a continuing dilemma that is going to be there in any society. Okay. And that's why the constitution and the basic structure becomes extremely important. What is the basic structure as we understand it? And this might change from time to time, but there are certain features of the basic structure which cannot change.
And I think whenever we come across these kind of competing rights, all that we need to do is step out of that immediate thing, go back to the constitutional principles, and fraternity. See, fraternity is never possible unless we also put ourselves in the opposite person's shoes and understand it from their context. That is when real fraternity can grow in this country. So I think we need to understand, okay, and it's not that anybody is perfect. Yes, there are, you know, there's a plus minuses everywhere. But then how do we all collectively work towards achieving the constitutional goals instead of more and more fragmentation? And, you know, it's like, to give you a more, you know, mundane kind of an example, is your vaccination against diseases. They keep saying, no, polio, unless every child is vaccinated, you can never eradicate. Smallpox was eradicated because every single individual, their rich, poor, caste, nothing, that segregation didn't work, no? Whether you're a Dalit or you're an upper caste or a, you know, OBC, whether you're man, woman, transgender, or, you know, whatever, every poor, rich, rural, urban, the last person had to be vaccinated to eradicate smallpox. It's the same thing. The last person has to inculcate the constitutional values if all of us need to enjoy the constitutional rights given to us under the Constitution.
Any more questions?
There's one comment by Vinuta and a question. I can read it out. So Vinuta writes, Article 368 clearly mentions which articles can be amended, and the chapters or lists, which is basically something to do with the federal structure and judiciary powers. From my reading in the limited time, I did not see these provisions harming an individual's fundamental rights. Where did the question of amendment of fundamental rights get entangled? Could you please shed light on this?
It's a more future-oriented point where you're saying once you open the door and say the legislature can amend anything it wants to, then that space opens out, you know. And you're right. I mean, it's more to do with the power between the struggle within legislature and the judiciary. That's where the conflict has been centered. In a technical sense, you're completely right. It's not on the fundamental rights question, but the point is the implications of the fundamental rights question.
Arvind, if I can add, the Keshavananda Bharati case arose out of an amendment to the constitution by which the fundamental right of owning property, which was a fundamental right, was removed. So Keshavananda Bharati was a religious head of a mutt in Kerala who challenged it, and that went to the Supreme Court. You see, so that is where the issue of fundamental right getting abrogated or transferred or annulled became entangled with Article 368, you know, and of course the basic structure doctrine came. In fact, one of the big push of the present government is to say remove out this basic structure principle itself. this basic structure principle is coming in the way of almost all the major amendments that is being sought to be pushed. And they say, so long as it is there, it might be difficult, so remove it altogether. And what I'm saying is, again, not just talked about in political platforms, it's been talked about in Parliament itself.
No, Suresh, I think the question is, she's reading the proviso to Article 368, where
Right.
in respect of certain amendments which encroach upon the powers of the state governments, apart from, Parliament passing it by a 2/3 majority of members present and voting, you also need to get the ratification from the states.
Correct.
So now, see, this is when we are talking about the basic structure, please remember it is not only restricted to fundamental rights. For instance, I mean, it went a little too quickly for us to, understand and actually dwell on each of these topics. But I think in Minerva Mills slides, which Arvind was showing about the opinion of each judge, or even in Keshavananda Bharati, if you see, each judge relies on a different concept to come to the same conclusion as to what constitutes basic structure. For instance, in the, not in Minerva Mills, I think in Indira Gandhi case, where Indira Gandhi brought in an amendment to the constitution to say that there can be no challenge to the election of a prime minister and a speaker, and kept them, outside the purview of judicial review. So at that stage, each judge struck down the amendment for different reasons. One judge says, well, it is, against free and fair elections. Another judge says, no, it violates Article 14, because how is a prime minister and a speaker above the rest? They are on par with other ministers or any other MLA or MP who is elected. So he says it's Article 14 is violated. So one judge says it is against democracy. Another judge says it is against the principles of separation of powers, because judicial review is a very basic to the Indian Constitution. And once you say that the Prime Minister and the Speaker are outside the purview of judicial review, and that means nobody can challenge it and no judge can get into the validity of that selection. In other words, you are making them go outside the purview of any adjudication. That is, they will not come within the judicial process. So one judge says that amendment is wrong because it's violating the principles of separation of powers, and in the legislature is asserting its supremacy, saying that the judiciary cannot touch me. So you are violating the principles of judicial review on one hand and separation of powers on the other hand. So if you read the judgment in Indira Gandhi's case itself, everybody comes to the same conclusion, saying that the amendment violates basic structure, but everybody's understanding of the basic structure was very different, the logic. So each of these things, so rule of law, Article 14, which is equality, then separation of powers, judicial review, democracy, free and fair elections. Now, all these can be culled out as being part of the basic structure. So similarly, when you are looking at Article 368 and the proviso to 368, what we should understand from that is inbuilt into the power of the Parliament to amend. They have, wherever the rights of the states are involved, the Parliament itself brought in a check saying that, well, you can't suddenly, usurp the powers of the state and make it unitary. You are then violating the federal structure. So we can interpret the proviso to Article 368 to mean that federalism is also a part of the basic structure of the Constitution. So tomorrow, supposing suddenly the Parliament brings a law and says, well, we have now decided that we'll bring in a presidential form of governance, and there will no longer be, assemblies at the state level. We'll have no chief ministers. There'll only be one president who will rule this country, or one prime minister who will rule this entire country. Now, that's nothing to do with the fundamental rights in one way. So if you're looking at it, it's after all only a change in, like, the American presidential form of government. We are moving towards that. But as far as India is concerned, now, does it affect the basic structure is a question which can be very validly asked. Because looking by the 368 proviso, if it is something which is taking away from the rights of the states, then yes, you need to get it passed by the state legislatures. They also have to agree. If they don't agree, that amendment cannot be passed. Now, tomorrow, can they bring in an amendment to say that section of 368 which provides for it, we will remove. Then again also, if you see in 368, there is one clause. If you want to amend 368, then once again you need to get the approval of the states. So you will find the features of the basic structure embedded in different parts of the Constitution. So it is not just that fundamental rights violation alone is basic rights, but so many other principles which are part of the identity of the Constitution. I mean, Arvind has been emphasizing on this whole thing of constitutional identity. So part of the constitutional identity of the Indian Constitution is federalism. It is independence of the judiciary. So tomorrow, if they bring in an amendment to say we are abolishing high courts and supreme courts, sorry, nobody can go to court hereafter. It is a violation of the fundamental rights. It is also a violation of the basic structure for the reason separation of powers, judicial review, all that is taken away. So you need to look at it in a larger perspective and not just fundamental rights. I hope I have clarified.
I have a question. The EWS judgment is referred that there is a minority quote from the judge that disagreeing with EWS, it is unconstitutional because it is discriminating the last 70 years. But when NIA has come, it has been told that it is unconstitutional. NRC CAA, when amendments have come, it has been told it is affecting the basic structure. And also abrogation of 370. When the critics have come that it is affecting the basic structure. But in every case, judiciary has ended up in acknowledging the amendments. So what can we infer out of this? Even though it is criticized as violating the basic structure of Constitution, these amendments, NIA, CANRC, abrogation of 370, EWS, everything is acknowledged by the judiciary, which is supposed to, actually this Article 368 or Kesavananda Bharati judgment, everything is about entangling between the legislature and the judiciary. But the judiciary soon lifted its hand and allowed all these amendments. So what can we infer out of this?
Well, I don't think we have much time left, but one line is you can infer that the law is a continuing space for struggle. You know? That there will be different kinds of amendments which will come up, and there will be a 5-judge bench, then you remove to a 7-judge bench. Take the case, for example, internal reservation. 7 judges said that internal reservation is not constitutionally valid. It's overruled by a larger bench. 5 judges said, 7 judges said not valid, then it's overruled by a larger bench. So you just have to think of the law as a space for struggle and think of how we can continue to take these issues forward. These are all big questions, but yeah.
Thank you.
There's one last question by Mohan. Maybe we could take that and close out for today. So Mohan writes, Article 25(2) says the state has the authority to regulate or restrict secular activities that may be associated with religious practices such as social reforms, economic activities, and other activities unrelated to the core aspects of religion. I see a self-contradiction. I cannot understand how can a social reform be carried out without relating to the core aspect of religion. According to Baba Sahib, the soul of the Hindu religion is caste, that is great inequality society. How does our constitution expect us to practice secularism or achieve any social reform without relating to core concept of religion?
My sense is we have to look at the 25 as distinct from constitutional interpretation. There might be an interpretation which is the essential features test, as it were. But it's argued that the essential features test, as far as to determine what is the essential features of religion, should not be the way of looking at 25(2), right? And so 25(2), you arguably, again, you read it more closely, you would say that the question of 25(2) is the idea of the Hindu religious space to people of all religions, very integral to it. And you read 25 in the context of 17, right? You read it intertextually. You can't read it as 25(2) as a standalone article. No article in the Constitution is standalone. So you read it in 17, practice of untouchability is prohibited, right? So the core aspect of religion has to be subject to the mandate of 17. Right? So you think of a way in which you relate various provisions to each other.
No, I think just to clarify, I think Mohan, what you see, you live to see that nothing in this article shall affect the operation of any existing law or prevent the state from making any law regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. So, for instance, I mean, again, we can take there are decided case laws on this coming from the labor law. You have the Tirupati Tirumala Devasthanam. Now, the question was, does the Industrial Disputes Act, which deals with labor law, apply to the people who are employed in the Tirupati Tirumala Devasthanam? And the Devasthanam's argument was, we are a religious body. We are not carrying out any business. So the Industrial Disputes Act cannot apply to us. So the argument of the workers was, well, we are all employees here, and you can't arbitrarily dismiss us, or you cannot, give us conditions of service. You have to pay us minimum wages. You can't treat us in a bad way. Essentially where the Industrial Disputes Act will. So the Supreme Court then makes a distinction. See, what the Industrial Disputes Act tries to do is to regulate. Here you can see the economic, financial, political, or other secular activity. Now, for instance, the cooks who are making the prasadam in the temple, that is a secular activity because it's cooking. It may be for a religious institution to give prasadam to the disciples, but per se making laddu is not a religious activity. So the state can regulate. For instance, it can, for recently there was this controversy that the ghee supplied to the Devasthanam in Tirupati was adulterated. So the health inspectors can go and inspect the Devasthanam and say that you are not maintaining adequate health and hygiene. Or the labor inspector can go and say that you are ill-treating your workers. Or you can say that, the women are not being given maternity benefit. You are not providing adequate toilet facilities. Or the municipal administration can come and say, look here, your buildings are falling apart. You need to maintain it. Safety of the people, that is people who are coming to the Devasthanam for to visit the temple, their safety is affected. So these are all the secular activities which may be associated with the religious institution, and your freedom to practice your religion does not mean the state cannot make laws to regulate these activities of the religious institution. So that is the context of 25(2). I hope. So finance, supposing they are making income, I'm sure income tax authorities can come and say that we levy income tax. If they are carrying out services, GST will be applicable. So there may be GST rates. If they are doing money laundering, then the ED will come. So merely because you are a religious institution doesn't mean that you are above law. They may not interfere in the actual carrying out of the way you may carry out your puja. You may have a particular method by which you carry out the actual the puja ceremonies and all that. That, yes, the state will not interfere because that is an essential part of your right to practice religion. But the rest of the areas, the state can regulate and bring in laws. So that is the meaning of 25(2), that it can regulate activities which may be associated with the religious practice, but which are otherwise on the face of it economic, financial, political, or secular. Is it clear? And like Arvind pointed out, supposing they say, like in Sabarimala, women cannot enter or Dalits cannot enter. Those are in clear violation of Article 17. So the state can say, bring in a law and say that it may be a temple, but that doesn't mean that you can practice untouchability. That is illegal. So that component of, because practicing untouchability can never be an essential component of your religious practice because it is in violation of your fundamental rights and constitution. So this is again the competing equalities that we are talking about. Somebody's right to practice religion cannot be in violation of my right to be treated with dignity. If you practice untouchability, it is violating the right of the person to be treated with the dignity, which is a part of the fundamental rights. So this is how you read 25. I hope that's clear.
Friends, we have crossed, we're 10:15. We will have to stop here. What I would request you all to do is to keep what Arvind had said earlier, that you cannot read one article of the Constitution in isolation of some other article. You cannot read two articles in the Constitution in isolation of the preamble. So we'll have to look at all of these things together. Look at what the Constitution has provided, the basic principles which are there in the preamble. And based on that construction and based on that interpretation, we take a stand on any particular issue. I hope that has been clear with the discussion today. I'm sure that there will be more ideas that will come. Senthil had raised a number of issues which are important. We need to discuss that, and let's continue the discussion in the WhatsApp group so that, any ideas that come to you, please don't keep it aside for some other day. Let the discussion continue in the WhatsApp group. If there are enough number of people, we can have smaller, what we call the mini quorums. That's also possible. Last week, we had a mini quorum. About 14 people participated. It was very interesting, very rich in terms of discussion on the previous lectures. Okay, we will have to stop the lecture today.